more or less ready to go, I think. Well, thank you everyone for joining us. This is the latest on our insurance series of webinars dealing with a variety of different topics. Some of you might have joined us before. You may have seen one I did on discrimination a while ago, and we've had various others on vicarious liability, etc. So if you haven't seen those, I think you can probably go back and watch them, and certainly join us in the future for other seminars that we'll be having. I do have to say this is being recorded, not that we can see any of you. It'll just be, unfortunately, my face and my colleague Gemma's for the next hour or so, but the webinar is being recorded, and that can be sent to you if you need a copy. We're going to go through, this one is about data protection and about claims relating to data protection as well, kind of ancillary claims that are often brought with them. And there will be a Q&A session at the end for us to answer any of your questions. There is a Q&A box, I think, or there should be, for you to ask any questions, and we'll ask those at the end, but feel free to post them as we go through, as and when things come to you. So we'll start now. I am pleased to be joined by my colleague, Gemma, who is a partner in our governance, procurement and information department, and it's testament to her skill and experience that I can barely even pronounce that, let alone know what she does in any great detail. But she this aspect of data protection is very much her bread and butter, and she's very knowledgeable on the subject and a very good speaker. So I'm very glad to have her working with me on this, and I will hand you over to her now, because she's going to do us a little bit of an introduction on data protection generally.
Thanks, David, and thanks for having me today. I'm really pleased to be a part of this, and good morning to you all. I'm afraid data protection isn't the easiest of subjects. It's not a very sexy subject to talk about, so I'll try and make it as interesting as I can. You're probably aware that obviously recently there have been a lot of data protection cases, and there seems to be a bit of an increase in data protection breach cases. One of the big ones recently was the one in Ireland with the police over there, who released a lot of information with regards to their officers, which caused a heck of a lot of controversy. And I'll touch on that when I speak on one of my next slides. But I'm just going to give you a whistle-stop tour of data protection before David gets into the real nitty-gritty and the bit that I'm sure you really want to watch. So I'm a partner in the GPI team, as we like to call it here. It's not very snappily titled, so well done, David, for saying that. And the first thing I want to talk about is just the data protection legislation and its principles. So obviously you're probably aware that the main bit of legislation in this country with regards to data protection is the Data Protection Act 2018. And that implements the General Data Protection Regulation, also known as GDPR. That was the original European legislation, and the Data Protection Act is what was brought in to support that at the time. Obviously, we then went through Brexit, and so we now have our own UK GDPR. So you have the Data Protection Act, and we also have the UK GDPR that govern this area of the law. They're not the easiest of reads, and the ICO provides guidance with regards to this, but parts of it can be quite grey and a bit tricky and a bit difficult. So just as long as you're aware of the general principles of all the legislation, and this applies as well, not just to data protection, but also freedom of information as well. But with regards to ensuring personal data is used, you must make sure it's used fairly, lawfully, and transparently. You have to have purpose limitation, they call it, which means that you only use it for a specific purpose. You're not holding it or gathering it or using it for just because you fancy it or because you think you might need it. You have to have a purpose for holding and processing that information. You also have to use it in a way that's adequate, relevant, and limited to what's necessary. And this is known as data minimization. So this is to stop you from holding reams and reams and reams of pointless information that you just don't actually need. You only are to keep the thing that you actually need and what is relevant to the purpose that you're holding it for. You need to make sure it's accurate and kept up to date. And you also need to make sure that you keep it for no longer than is necessary. And this again relates back to that purpose limitation and the data minimization. It basically says, if you don't need it for that purpose anymore, then you have to get rid of it. Gone are the days of keeping things for hundreds of years, which us lawyers hate, by the way, because I like to keep everything forever, because you never know when it might be useful. But unfortunately, under data protection law, that's just not the case here. So as soon as you've used it for the purpose of which you require, then you need to be getting rid of it, unless you have a justification for holding it. And you also need to make sure that it's handled in a way that ensures you've got appropriate security, and that includes protection against unlawful or unauthorized processing, access, loss, destruction, or damage. So, you know, it's quite a hefty piece of legislation. And like I say, it is becoming more prolific with more and more cases coming through. But those are the main underlying principles of the Data Protection Act. If you could pop onto the next slide, please, David. He's in charge today. So there we go. So just some examples of data breaches for you to consider. So the most common one, which I find, is emails have been sent to the wrong address. Unfortunately, we have this thing now where we have auto type, where you just put like the first couple of initials and then it brings up an email, doesn't it? And a lot of the time it can just be sent to the wrong email address. That happens quite a lot. That is a massive part of data breaches, I would say. Lost USB sticks or lost laptops and computers, obviously, they just can't be found. So that data is out there somewhere and we don't know where it is. Improper use of CC or BC in emails. So that's when you copy somebody in or you blind copy somebody in. Again, that ties back to the emails being sent to wrong addresses. People just type in the first few initials, press enter, and it comes up with an automatic name. And a lot of the time, it's actually not the person you want to send it to. We have quite a few Gemmas here at Forbes, so I regularly get finance information because we have an accounting lady here as well called Gemma. And every time I get it, I have a heart attack because I think I should know about this. But so it happens everywhere. But yeah, BC and CC into emails is a big part of data breaching. I mean, a lot of people now are trying to be paperless and they're trying to be more electronic, but we do still have instances where letters unfortunately get caught on other letters and they end up going in an envelope and sent to the wrong place, or they can be sent to the wrong address. We have data breaches where you are, for example, if someone submits a subject access request and you fail to redact those documents correctly before sending those out, you can end up automatically disclosing somebody else's personal information if you haven't redacted that properly. And then again, unencrypted laptops. Encrypting of laptops and passwords on documents and things like that now is a massive area. But believe it or not, there are still things out there which are unencrypted, and so people can just easily access the information that's upon them. Next slide, please, David. So we're moving now on to the legal consequences of data breaches. Now, the Information Commissioner's Office is the main regulator with regards to data protection, and they do have quite substantial powers, one of which is to issue fines. And as you can see, as it says on the slides, that can be up to 17.5 million or 4% of the annual worldwide turnover in the preceding financial year of that body, whichever is higher. So if it's over 17.5 million, you can be in a sticky situation. However, I think it's fair to say that the ICO have been quite reluctant really to use those powers, and any fines that have been dished out have actually been quite limited. In comparison to the potential issues with the breach. I mentioned the Irish case before recently, which was all over the news about the police force that released information on its officers. And I think the ICO in that case, they said that they could have fined up to 9.2 million, I think it was that they said. And in the end, they only submitted a fine of £700,000, which quite shockingly, the police force still tried to appeal. And I was quite shocked. I thought, blimey, you've got a brass neck, because I certainly wouldn't have the guts to go back to them when they could potentially fine me for 9.2 million. Anyway, that appeal was rejected, but it was because they were saying it was a public body and you were taking away money from a public body. However, on the flip side of that, there were all the safeguarding issues of their officers, particularly in Ireland, and with the issues that they've had historically. Obviously, it was a massive concern, and it potentially opened up a lot of problems with regards to the release of that information. So my personal opinion is 700k is not a bad fine to be getting for that. The ICO can also issue reprimands. They can require that audits are carried out. And those are the main things that the ICO can do, is your fines, your reprimands, and your audits. Individuals can then apply to court if you have breached their data rights. So if you have breached their personal information and you've done something with their data and processed it or released it or done something that you shouldn't have, they can bring a case against you. Courts in that case can order compensation, and it can be quite significant, the legal costs relating to that. But there's also other consequences, such as adverse publicity, as you can see with, I mean, there's been all sorts of cases recently, but the adverse publicity, it's all over social media, it's all over the news. Reputational damage as a result of that. Obviously, if they think, oh, blimey, they're not very good with data, that can have a big impact on your reputation. You can also have potential regulatory investigations as a result of it, and you can have a loss of business continuity. So there's lots of consequences other than just what is in place with the ICO. Next slide, please, David. So just a little bit now on how to prevent data breach claims. And I think the first and most important one for me, even though it's further down this list on here, is your staff training. That is vital. For any organisation, it is making sure that your staff are aware of the issues and that they have the knowledge. You also need to make sure that any personal data which you do hold is stored securely and is in good enough technical form, which is required under the legislation. You also need to make sure that you have strong policies in place. So remote working, security audits, things like that. Those policies need to be in place. So if for whatever reason there is a data breach, you actually have a policy to start from and you can ensure that it has been followed and everything has been in place. You need to be able to show that you have taken all the required and necessary steps to prevent those data breaches. Otherwise, it's very frowned upon and it could end up leading to more punishment. Careful redaction, that's really, really important. Obviously, if somebody makes a subject access request for personal information, and as I mentioned before, if you're taking other people's information out, you accidentally leave it in. So redaction is really, really important. Staff training, as I've mentioned, but also who has access and why. Do they need access to that personal data? If not, why have they got it? Keep it minimal to whoever actually needs to be able to access and store or process that personal data. And then just making sure that you implement the required cyber security measures and tighten up your technology. Use that encryption and make sure the systems that you have are robust to protect your staff and also everybody else with regards to these data breaches. I think that's it, David. If you want to go on to the next slide, I think that should hopefully hand over to you then. There we go.
Yep, it is. Brilliant. Thanks for that, Gemma. Yeah. So as we can see, obviously some quite significant reputational and financial consequences for these matters for data breaches. And I'm now going to go on to dealing with claims, the kind of claims that we get, the kind of ancillary claims, and how we can best manage those. So we're going to start just by looking at the causes of action, because we need to understand those causes of action and where they come from in these kind of cases to know how we can respond effectively. So Gemma's already given you some of the background to it. For our purposes on the claims side of things, the Data Protection Act brings in, as Gemma said, the UK GDPR via various articles, and some of the most important ones for the purposes of claims are on the slide here. We've got the right to an effective judicial remedy and the right to receive compensation for any damage suffered. There are exceptions to that. I mean, if you remember, there's no involvement of malice here or intention. A breach is actionable and is potentially compensatable, but there are some safeguards in there. So, for example, there are some provisions that only apply to data processors, which means that data controllers aren't liable. And there is a general defense for if you aren't in any way responsible for the damage at all. So, for example, you may say, well, we've been hacked by somebody, by a hacker. We've had a cyber attack, and that's not our fault. That's somebody else's fault, and potentially true. But at the same time, there are risks involved and potential liabilities for that as well, which we're going to come on to in a second. So we've seen some examples of what are data breaches, most of them being human error. We do get things like blagging, loss or theft of physical information or electronic information by deception, introduction of ransomware, cyberware attacks, even physical things as well. I mean, the Data Protection Act is not just digital data, it's physical data as well. So water leaks and break-ins and flooding and that kind of thing are all potential risks to us. So as I said, there is a right to compensation when a breach occurs, regardless of kind of intention with that, but it is finely nuanced. So you could say, if I'm the victim of a cyber attack, it's not my fault, but it depends really on the circumstances. You may well have heard that there are 7 data protection principles within the Act, and one of those is, as Gemma pointed out before, to protect data against unauthorized or unlawful processing, against accidental loss, destruction, damage, and you are required to use appropriate technical or organizational measures to deal with that. So whilst you might not be responsible for a criminal act against you, at the same time, if your measures aren't suitable enough to take basic steps to protect against those, then you may still be in breach. So for example, if an employee has access to data at work and is allowed to copy private data onto a disk and then ends up going and publishing it, well, that person may well be responsible for that misuse of that data. But there are IT systems that you can use to prevent that from happening. So my firm, for example, doesn't allow external media like USB sticks, etc., to be placed into machines to copy data as a basic protection. And it's very easy to do. And there's no real reason why organizations shouldn't do it, subject to operational requirements. So if you can be criticized in that respect for failing to take some measures, then you can still end up being fined or subject to a claim for damages. Same if you, for example, you choose to use a company to store cloud data that's offshore somewhere and they don't have as stringent data protection regimes as we do in the UK, for example, and then information goes missing. So that's data protection and how those claims come about. But we very often have ancillary claims that come with data protection litigation as well. Misuse of private information is one of them. The basic premise of this is to try and protect human autonomy and dignity. And really, this came about in recognizance of the fact that the European Convention on Human Rights, brought in by the Human Rights Act 98, of course, requires the courts to act in a way which protects individuals' right to respect for private life under Article 8. And that comes with it the right to control the dissemination of information about your private life and the right to, as the court puts it, the esteem and respect of other people. The aim is to balance the Article 8 right to private life and the Article 10 right to publish information that's of concern to others, the right of freedom of speech in the ECHR. And MPI claims misuse of private information is really the unauthorized or unjustified disclosure of private and or confidential information. And private information is just as you would expect. It's personal information. It's private due to its nature. Things such as an individual's health history or sex life or whatever else it may be are private matters that shouldn't be in the public domain under normal circumstances. But it does require a realistic expectation of privacy. It's usually quite obvious when that is. Your medical records, clearly there is an expectation they will stay private, but it's not always that simple. We've come across situations, for example, where people have made representations on a local authority's planning portal and given their personal details whilst doing that. And we have had a case where some of those details were then published on the portal by mistake. So quite a straightforward breach. But the actual objections that were made on the planning portal were made it quite clear who was actually making the objections in the first place and where they lived, etc. So it's a little bit more nuanced than is the data personal or private per se, because circumstances may dictate that there was no actual expectation of privacy in that particular circumstance, even though normally it would be private. And we'll go on to consider some examples of that soon. And the court will consider the nature of the activity that the claimant was engaged in, where it happened, the purpose of the intrusion, whether there was any consent, either implied or express or whatever. And the court will also look at whether a reasonable person of ordinary sensibilities would find the disclosure offensive. And it must be more than merely trivial. So you will probably have come across many cases where there's been a potential breach on the face of it. But in the end, has it really caused that person any distress or harm? Or is it really just a merely trivial or technical breach? For MPI cases, there must have actually been some kind of misuse as well. So there must have been an actual action. There was a case involving Currys where they resold a television secondhand, and it was a smart TV, and they hadn't wiped the previous owner's data from that, and they were sued. But the court said failing to do something isn't a misuse of private information, it's just an omission. You have to actually misuse it in some way to be liable under this. There was another case against an NHS trust. They used a private contractor to come into the hospital, and they were allowed access to patient records, which was fine. But that company then unlawfully accessed other paperwork which they hadn't been given access to whilst they were on those visits. And the court again said that's not a misuse of private information by the trust, that was by somebody else. That was a kind of criminal intervention almost. The intrusion itself can actually be compensatable in these cases as well. If you look at the phone hacking cases, for example, the claimants were compensated separately, both for how the information was used, so the publications in the newspapers, etc., but also for the fact that their phones had been hacked in the first place. It was the fact that voicemails are private between two people, and accessing them was an unnecessary and unjustified intrusion into their private lives. So for that reason, it doesn't necessarily even need to be published as such. It just needs to be misused in some way. What kind of cases are we talking about with those? Your typical kiss and tell stories in the newspaper, publishing private information online, leak of medical information, trade secrets, that kind of thing. And this mainly came about, really, it started with the Naomi Campbell case, which you might remember from quite a long time ago now. She was photographed coming out of a Narcotics Anonymous meeting in London, and she was covertly photographed, and that was published in the newspaper with an article which obviously insinuated that she was a drug addict. And she sued the newspaper for breach of confidence under the Data Protection Act, misuse of private information. And at first instance at court, she was successful and she got compensation, but then the Court of Appeal overturned that. And the reason they overturned it was because she had previously said openly in public and in the newspapers that she wasn't a drug taker. She didn't take drugs, and this news report was necessary in dispelling that myth and countering a false report. But then it went to the House of Lords, as it was then, and was overturned again, and she was reinstated with compensation. And they said that the information about private medical treatment, etc., was private and confidential, and there was a reasonable expectation that it should stay confidential. Interestingly, the House of Lords did say that publishing some information to counter that previous false statement was actually reasonable, but some of the information posted wasn't, including the photographs, because they take photographs as being quite a serious intrusion of privacy especially when they're taken covertly. And that was an unjustified intrusion into her private life. So it's balancing this right of freedom of speech under Article 10 in the press and the Article 8 right to a private life. Breach of confidence is subtly different, but it's similar. Again, it's often brought in conjunction with data protection claims. This is where information received in confidence is then used in an unauthorized way. So it's confidential information, secret information. And confidential information is different than private information. It is it's confidential because of the nature of its how it comes into existence, and that can be either by an express agreement or by a relationship. So, for example, an employment contract may specifically have a term in it which says that that trade secrets shouldn't be passed to anybody else, and doing so would then be a breach of confidence in that situation because it's confidential information. But then also information held by your GP is confidential information because it's health information, and that's implied into the relationship between a doctor and patient and the privilege that applies with that. And information can be private and confidential, but it's not necessarily both at the same time. Again, it has to actually be misused and used in an authorized way. So an employee who takes private information over the phone as part of their job and then enters it into a database is using private information or confidential information in some circumstances, but they're not misusing it. If they then take that information and disclose it in the papers or send it to others or whatever, then in that situation they are potentially misusing or using the information in an unauthorized manner. There are some exceptions. You can consent to it. You can. It might be necessary to safeguard people, or in the public interest, or you might be subject to a legal duty, like an order requiring you to disclose information. A lot of the cases are similar to what we're dealing with misuse of private information cases, media leaks, sharing private information, sharing trade secrets, accidental disclosure of medical information could be as well, because it's confidential as well as private information. But really what we're looking at is does it have the necessary quality of confidential information, and has it arisen or been obtained in that manner and then used or abused in an unauthorized way. So dealing then with claims when they first come in, or complaints as they may be first, is about damage limitation to begin with. Has the breach been remedied? A number of cases that I've seen where there has been a breach which has been acknowledged and even apologized for sometimes, where actually that they've not taken the simple step of actually then remedying it immediately. You know, if you send a letter to the wrong recipient, there can be a tendency to think, well, it's done and dusted, the breach has happened now. But can you go around and get that letter and recover it? It's a bit false. What does it actually do? That person might have copied it. They might have passed it on already. You just don't know. But later down the line, your actions may be subject to scrutiny. And the more you've done to try and minimize the consequences of a breach, then the more favorably that will be looked upon, because it might not have been passed on. That person may have done nothing with it yet. But if you leave it for a month, then maybe they will have done. Gemma's already talked about the requirement to self-report to the ICO. You've got the time limit of 72 hours to do that in cases to which it applies. And sometimes something as simple as an apology can go a long way. Sometimes I can see when these cases come in that the claimant's more dissatisfied or aggrieved by the way that their complaint's been handled as opposed to the actual original breach itself, and sometimes just apologizing and putting it right and explaining and taking them through the process of how it will be prevented from happening again is enough to kind of nip these things in the bud. So you've dealt with the initial fallout of the data protection, and I don't want to of the breach, and I don't want to go into too much detail about that, because you'll generally have your policies and procedures in place, and you certainly should do, and each is kind of bespoke to your own organization. But then once we've done that, we need to consider the substance of any actual claim that comes in. So this is when you've had a letter before action, or a litigant in person has contacted you to say that they want compensation for that. And we need to look at the duty of care first in these cases, because this is quite a difficult subject area, and sometimes it can be overlooked. We're going to go through the elements of the claims and work out how they can be counted in each situation. So interesting case, Smeaton and Equifax, quite a long time ago now, but Equifax is a credit reference agency. Between 2002 and 2006, they held data on their files that said that Mr. Smeaton, who sounds like a made-up character to me, but was a real-life person, they said that he was subject to a bankruptcy order. They had that on their file, but in actual fact, the bankruptcy order had been rescinded in 2002. So they held that information for 4 years, unwittingly, I might say. This was no deliberate act. He approaches a bank, Mr. Smeaton, and he says he wants a business account and a loan, but that was rejected, and the bank says they were rejecting it because of adverse data on his credit file. So he then finds out why that is, and he brings a claim under Section 13. This is the original Data Protection Act, which of course has now been updated in the 2018 version. And he sues in respect of negligence, breach of duty under the common law. And he said that what happened was that he couldn't raise finance for his company, which meant that he couldn't forecast profits accurately. And ultimately, that meant that his business failed and closed down and was responsible for his ultimate descent into homelessness, would you believe? So quite a substantial claim. And the court at first instance agreed with him and said, look, yeah, if you're going to run a credit reference agency like Equifax, then you owe customers a duty to do that with reasonable care and skill. So they found for him on both the data protection and common law claims. But that was reversed by the Court of Appeal, that said that it wasn't just or reasonable to impose a responsibility to the public at large just because you're a business deciding to act as a credit reference agency, as that could potentially give rise to and liability for an indeterminate class of people. Which I've got to say I have some difficulty with. I mean, most businesses, lawyers included, if you act for customers, you have to do that with reasonable care and skill. And nobody was suggesting, I don't think, that Equifax owed every single person in the world a duty of care, just people whose data they held. So I have some sympathy with the claimant's argument in this case. But what the court did say really is that the Data Protection Act is a detailed code. It's a self-contained code that deals with civil liability for improper processing of data. So there's no need for the tort of negligence to be brought into it. We can deal with data breaches within the Act itself. And that was then followed far more recently in Warren and DSG Retail. This is one you may remember where hackers infiltrated the DSG system, introduced malware, and stole customers' data. They were given a pretty hefty slap on the hand by the ICO, a £500,000 fine. And that was for breaking the 7th data protection principle, incidentally. So this is a case where they were actually fined for not taking sufficient technical measures to prevent hackers. So although they were hacked and that wasn't their fault, they should have done more to prevent that hacking. So that's a good demonstration of how you can still be held responsible in that situation. And the claimant sued for breach of confidence, misuse of private information, and negligence. And the court in that situation agreed again that there's no common law duty of care owed, and that there is no claim in negligence. And there was an interesting point about causation on that, which I'll deal with later, but that's been upheld. So there's no, these claims should not be brought in negligence if that's what you're seeing coming through landing on your desks. And in the Warren and DSG case, as well, as I said, they also sued for breach of confidence and misuse of private information. And they were struck out as well on the basis that the both of those causes of action prohibited the holder of data from dealing with it in a manner inconsistent with the obligation of confidence or privacy they had. So in other words, it's this point about positive action. Again, you have to actually do something to misuse the private information or to use the confidential information in an unauthorized way. And that word misuse means it's misuse, so it's actual use, of course. You have to have used something. The court actually said, in true judge lawyer speak, that there was a negative obligation not to disclose confidential information, which sounds like gibberish to me. And if you can work that out, then good luck to you. But double negative is something that lawyers are very common, very quick to use. But again, that is an example of a case where those causes of action failed. because of that. The claimants did use a fairly novel argument that allowing that data to be stolen and then published elsewhere, their actions were tantamount to publication. And I always think if you're using the word tantamount in your legal submissions, then I think you're probably already floundering. I think it's fair to say you're basically saying, come on, George, it's more or less the same thing, isn't it? I know we're not quite there, but it's pretty much the same, which isn't really how the law works. So not a brilliant argument to use, really. And this again was followed in the Smith and TalkTalk case, a group action by claimants after data was stolen in a cyber incident from TalkTalk. And incidentally, this occurred around the time that the Warren and DSG ruling came out, so they had to amend their pleading to try and get around the effect of that, because they tried to pursue a negligence and MPI and breach of confidence. And the claimants in that situation said, well, hang on, but TalkTalk had actually carried out certain positive actions. They'd done, I won't bore you with the details, but they'd actually done certain things which had paved the way for that cyber attack to occur. So that was the action that was required, the positive action that was required for misuse of private information. But the court was not swayed by that at all. The MPI claim was struck out, and they said that creating a vulnerability enabling fraud by others wasn't positive action. And this was still very much a case of a breach of the common law duty. And they also argued during the course of this, again, a relatively novel basis, that the Warren and DSG case was wrongly decided, which again, I think is probably the second nail in your coffin if you're using that during your legal argument. Standing in front of the High Court and trying to persuade them that the Court of Appeal was wrong in their decision is not going to really do you any favors in that situation. And then dealt with again more recently in the Stout and NGN claim, a case involving the Stouts. You may remember a couple who took £2 billion worth of PPE contracts from the government during the COVID pandemic, and they sued the newspapers for misuse of private information after various photographs were published in the newspapers. The photographs were of their brand new beachfront house that they'd built in the Bahamas, them walking along the beach and using their boat and jet skiing to the whole family jet skiing on a fleet of jet skis, I should say, to the local restaurant. They said that was a breach of or a misuse of their private information. Some interesting comments from the judge. The judge said that they needed to prove they had a reasonable expectation of privacy, which we've already covered and we know. They recognized that photographs can be particularly intrusive, but what they also said was that photographs taken in, just because a photograph's taken in public doesn't necessarily remove the expectation of privacy, because you can carry out a private act in public. We don't want to go too far into what that may be, what circumstances that may arise, but you could be looking after your children, for example, or playing with them in the park or whatever. You're in public, but is it a private family moment? And in this particular situation, there were other members of the public on the beach nearby. So walking on the beach didn't really give them any realistic expectation of privacy. Other people could see them doing that anyway. But the court did agree that photographs of their house and the boat they were using, etc., was private information, which didn't need to be in the public domain. And this is actually a case about an injunction. So an injunction for those photographs was granted, but not in relation to publication of the other photographs. So that gives us an outline about the different causes of action. So once we've got these claims in, we're looking at, is there actually a cause of action in the first place? What's it being brought under? Because these, in my experience, very much use a scattergun approach. Every argument under the sun is being made, and yet not everyone will apply in every case. But claimant solicitors don't tend to really care about that. That's not their duty to. They will set out all the allegations that could be true, and they will make you look into it, and you have to give a response on all of those. So that's why it's important to consider those carefully. And then after that, once we've looked at whether there's a potential for a breach, is there a duty and has it been breached? We're then looking at causation. And when I'm talking about causation, I'm talking about making a continuous link between the breach and the resultant loss. And it's an important point of law that's sometimes overlooked, actually, but it can be really quite a useful tool in our armory. And it sometimes manifests in practical terms as a kind of just like an uneasy feeling, a kind of intuitive feeling that it seems a bit far-fetched or a bit unlikely. And if we've got that kind of feeling, then generally there may be a causation argument rather than a liability argument. I said there was an interesting causation point in the Warren and DSG case, and that was that they tried to bring a negligence claim, which ultimately failed. But the judge actually pointed out that the claimant in that case actually hadn't suffered any financial loss, nor had they suffered any physical injury or psychiatric injury. And of course, in negligence claims, if you're claiming injury, you need to prove that you suffered an injury that was a recognizable psychiatric injury, and they hadn't suffered either. So even if there was the potential for a duty of care in negligence in those cases, actually there was no case on causation anyway, because there's nothing they could be compensated for. And this is a case that's coming before the Court of Appeal. This is a big case and an expensive case, and yet at no point seemingly had any of the lawyers taken stock and said, do we actually have a case in this situation that we can proceed with? In the Smeaton and Equifax case, the credit reference agency holding the incorrect information, when it was investigated, it was actually found that that file contained quite a lot of adverse, or certainly some other adverse information. So not just about the bankruptcy, but about various other negative aspects of the individual as well. So can you really say that refusal of the loan was down to that bit of incorrect information at all? So it's not a case where it's caused or contributed to. You have to prove that it has actually resulted in it, in the loss. And in that situation, that's very difficult to prove. So that was difficult to prove because of the fact that there were various factors involved. But then on top of that, there was another factor, and that is that Mr. Smeaton is claiming that his entire life's been ruined. His business has fallen apart. He's lost his home. He's become homeless. Well, it's a pretty far-fetched stretch of the imagination to say that being refused a loan by a bank ultimately ends up in you being homeless. I mean, there's lots of things that have to happen before you get to that point. And is that a normal, inevitable, or usual result of being refused a loan? Well, no, really. And does that indicate that the business was on its last legs or poorly managed anyway? So they're all going to be matters that need to be looked into when investigating these cases. There was another complicated matter of insolvency law in that as well, which I'm not going to go into or bore you with, but basically it was tantamount to saying, I'm using that tantamount again now, but luckily I'm not in a legal argument now, but they were effectively saying that the legislation was wrongly drafted and that the Secretary of State should be lobbying for it to be changed. Well, again, a claim for damage is not an appropriate forum to say that everything's wrong and should be done with differently so that it suits me in this particular situation. One example of that, a practical example of that we've dealt with, for instance, is where adoptive parents have alleged that their surname has been disclosed to the birth mother of the child that they adopted, as a result of which they were able to track them down on social media and send them a message. And they alleged that they were so scared of this person and her, frankly, choice kind of boyfriends that she had been with, that they were required to move house, move their businesses, etc. And they said that this breach therefore caused all that loss. Well, in reality, is that a proportionate response? This message that they received wasn't threatening. It's actually quite nice. It's quite polite. There are other steps they could have taken, really, to, rather than just the knee-jerk reaction of moving house and their businesses. So when looking into that case, really, it seemed that there were other factors at play which weren't being disclosed. Perhaps they wanted to move house anyway. They needed a bigger house, and this seemed like a convenient excuse. So taking what the claimant says on face value, which I know we never do, but taking their losses on face value as being the result of a breach is something really that we need to be avoiding and need to be questioning. And this quote here is from a recent case of Rolf, and it shows the court's more recent attitude towards some of these cases. In the modern world, it's not appropriate for a party to claim for breaches of this sort, which are frankly trivial. Traditionally, these are high court cases, cases that involve defamation or misuse of private information, etc., are generally high court cases, and that's where they should be started in the media and communications list of the High Court. If you've got a case that really where nobody's suffered any real damage, and you're arguing over a piece of law which doesn't really have any effect on anybody, then is that really an appropriate forum for them? And then, so we've looked at duty and breach of duty. Then we've looked at causation. So now we've got through that bit. Yes, okay, we've got the breach of duty, we've got the causation, and we're going through to the loss now. What's actually been suffered? And the general rule, as we know in civil law, is to try and put somebody back in the position they would have been in if the wrong hadn't been committed. And that will be financial losses, what we call special damages, and any general damages, any unquantifiable detriments that are still a loss, so personal injury and loss of opportunity, etc. As we saw in the Warren and DSG case, that in tortious claims and negligence, there has to have been an actual proper loss, so a financial loss or a personal injury in the form of physical or psychiatric injury, and anything falling short of that isn't actually compensatable, and there's no case. But the data protection claims themselves are very different. As I said, it's a standalone code, a standalone area, and section 168 of the Data Protection Act, the latest version, brings into force the right to compensation from the GDPR. And it specifically allows awards for material and non-material damage, specifically in claims for distress. So the bar is much lower for damages in this kind of case. You don't have to have suffered an injury, only the distress. There's been some case law about whether you need to prove distress or not. In a lot of situations, it's going to be implied. If your very serious medical information is published online by somebody, for instance, for example, you're very likely to have suffered some kind of distress as a result of that. You don't need a medical report to prove that necessarily, but you do have to show that there has been some distress. That quote that I gave you a minute ago is from the Rolf case, in that the claimants tried to get damages for distress after an email was sent to the wrong recipient, and they claimed that the email going to the wrong person made them feel ill. Actually, they were so distressed, and the court basically laughed that off. And there was no real serious information. That there was no prejudicial information that they would be worried about, and the judge just said that's completely implausible. Having said that, the eggshell skull rule does still apply. So just because a more robust person wouldn't suffer distress doesn't mean you can't be compensated. And it might be that you're suffering a particular, maybe you're already depressed or anxious or whatever, and you suffered distress because of that. So you can be compensated in that situation. Famous people are, the default position is that they should have thicker skins according to the courts, because they're used to being in the limelight, and of course they rely upon that to a certain extent, but they are generally compensated higher as a result, because the effects on their reputation can be far more. So Cliff Richard, for instance, received £210,000 from the BBC when they showed the police investigating his home in relation to historical sexual abuse. Us mere mortals, people like me, nobody cares what closets I have, skeletons I have in my closet. Maybe a few select people, but certainly compensation for my distress is nowhere as valuable as Mr. Richards is. There's also been case law on whether you can be separately compensated for loss of control. Loss of control is the fear that because your data's out there, you don't know what happens with it or where it's gone or who's doing what, and that in itself has been said to be separately compensatable, although recent cases, Lloyd and George, for example, said that you couldn't do without proving any distress as well. And there's got to be some clear value in the data, such as in the phone hacking claims, for instance. Sorry about that. I've accidentally lost the slide with by one of our pop-ups on here, unfortunately. So, but I hope you can still see that. So you might recall Donald Trump had another go on this issue recently. His claim was struck out as well. His was quite a complicated claim, in fairness, but part of it was that after the new Data Protection Act came in, some memoranda had been stored containing false information for longer than it should have been, in effect, is what we're saying. So he was saying that caused him distress, and that he was entitled to nominal compensation just for holding the inaccurate data in the first place. And the court threw that out and said, no, you're Donald Trump. You're clearly not distressed by many things in life, certainly not somebody holding your data unwittingly for a period of time that you didn't even know about. More serious consequences in some other cases. TLT against Secretary of State was the government accidentally publishing details of asylum seekers online for a period of 2 weeks. And they were compensated based upon their overall distress. There was no separate award for loss of control of the data, but it was taken into account when the damages were assessed. And there was some actual evidence from IP addresses that the information had been accessed from countries that were hostile to where they came from. So some real potential threat of damage there for those people. And that can be summarized really with that quote as well. We're in the 21st century. There's a lot of information available, particularly online, and we have to take with a pinch of salt the claim that people have suffered distress as a result of certain data breaches, and we certainly need to question it quite vigorously. In the Rolfe case, the claimants were actually ordered to pay the defendant's costs due to exaggeration and the lack of credible evidence of distress. So that's something, again, that we have in our arsenal. Just drawing all of this to a close now, claimants, I've said before, often use a scattergun approach. They make allegations under all the potential causes of action. We've not got to be led by them in respect of that. According to letters before action, every single letter before action I've ever seen, this was an extraordinary breach of the utmost importance that has taken an unmentionable toll on their clients, required all sorts of treatment and devastation, and it's the worst thing ever. But it almost never is, and almost never has, and that's becoming more recognised by the courts. Johnson and Eastlight was a case in which the claimant's rent statement was sent to a third party by mistake, and the claimant issued proceedings again in the High Court, breach of Data Protection Act, various other claims as well. And the court looked at it all and said, and agreed the defendant's argument that the claims collateral to the GDPR claim, the misuse of private information, the breach of confidence, they were superfluous really to requirements on top of the data protection matter, and that they may obstruct the just disposal of the proceedings and take up a disproportionate and unreasonable court time and costs. And the claim was then transferred down to the county court with a recommendation actually that it go into the small claims track as well. So we do need to be questioning whether these cases need to be are as severe as they are, if the effects are severe as they are being claimed to be. Similar thing happened in the Currys case that I mentioned, where they didn't wipe the previous customer's data from the smart TV. Again, the MPI and breach of confidence claims were struck out because they duplicated the data protection claim. The courts aren't going to prevent you from bringing the claim. They're not going to strike out the case entirely, but they want to cut it down to the bare bones of it. And they need to say, look, what is the actual question we need to answer here, and how do we deal with that in the best way? And in the Warren and DSG claim, for example, the DPA, the data protection claim, was allowed to continue. Same with the Rolfe claim, etc., although it was reallocated to the small claims track. There will also be, in some letters of claim, they will threaten damages, an injunction, and a declaration. Realistically, are we going to go to the High Court and seek a declaration that someone's human rights have been breached because an email went to the wrong person? I mean, most of the time, that kind of remedy is ludicrous, and the claimant doesn't even want it. Do they want a declaration, a piece of paper that says they were wronged in some way? What they want, 9 out of 10 9 out of 10 situations is the cold hard cash, unfortunately, for the breach. So I think that takes us to the end really now of the webinar. We just have some time for any questions. If anybody has any, you can put your hand up, type them in the Q&A, or whatever you want. The other way, if you don't want to be brave enough to highlight them on here, is to get in touch with us afterwards if you want to, if that helps. I can't. So Gemma, you haven't had any questions, have you? I can't see any on the Q&A. No.
Not that I can see.
No. Okay, fine. All right. So I think then probably, like I say, if anyone has any particular queries on certain cases or anything, then you can get in touch with Gemma or I to ask us the queries. Our contact details are on the slides, which we can send out to you anyway. This is part of a series of seminars, but we also have lots ongoing. Gemma does her own as well in her particular field, and our website has all of those set out for you to have a look at and to register for. And we also do bespoke training, things like mock trials and more practical events and workshops, etc., as well as short seminars, and we can draft those bespoke to your particular organization. If you want us to, just get in touch. We're always happy to help with things like that, and it could be a lot of fun, can't they, Gemma? You do a lot of those kind of things, don't you? So,
Yeah, I love doing those. I'm a very good actress.
Yes, you are, most definitely. So thank you for your time today. Thanks for joining us. Nice to see some friendly faces on the list that have joined us on previous seminars before again. So we hope to see you again soon, and you take care, everybody.
Bye, everyone. Thanks, David.
Thanks, Gemma.